wondering as to where is Edzorb Law with the MP analysis? Well, here we are with a loaded and action-packed analysis. It is as immaculate as a reading material and as beautiful as the most illustrative and catchy depiction you have ever come across. More than anything, all of this is free for you. Feel free to pause where required and absorb our rich and detailed content. While I'm sure many of you are bruised in places, after the paper of course, काफी चोटें लगी हैं, काफी bounces थे. I am sure talking helps. Enough chit chat, let's jump to the first question. So you open the question paper and the first question is a statement. Now quick tip, whenever you come across such statements, always read them twice. So the statement here is, writ jurisdiction of the Supreme Court is wider than the High Court. Now the obvious confusion is because there is a comparison between Supreme Court and the High Court, and one may be naturally inclined to think that Supreme Court is having the wider jurisdiction. However, if you've gone through our QBanks and if you can remember, Article 226 talks about issuance of writs to any person or authority for the enforcement of rights conferred by Part 3rd and for any other purposes, whereas Article 32 is only concerned with enforcement of fundamental rights. Therefore, I think you could have easily marked the correct option, which is that the statement is incorrect. And I'm sure that questions like the second one edge you to mark social, economical and political justice when it is concerned with Article 38, and I think you must have earned 1 point by marking the option D. However, as you can see, we have extensively covered Article 38 in our material and the question banks, which you can easily have access to the next time around. Now, while designing our question banks, we were extremely careful to cover Article 13 of the Constitution of India, which, as you can see, we have covered extremely well. Question number 3 remains to be a direct question from Article 13(2) of the Constitution of India, which would tell you that the state is prohibited from making any law which takes away or abridges any of the rights conferred by Part 3rd. And therefore any law made by the state which takes away or abridges the rights conferred by Part 3rd shall be void to the extent of the contravention. I am sure you were able to mark the correct option B. Now the fourth question was also covered by us in our QBank, and we found that Lata Singh versus Union of India recognizes the right to marry as a fundamental right. Now there have been subsequent reiterations of this, that the right to marry is in fact a fundamental right. It is in fact also recognized by the Universal Declaration of Human Rights. Now a recent reiteration of the same law is there in Shafi Jahan case, where the Supreme Court has found the right to marry the person of one's own choice to be integral to Article 21 of the Constitution of India. So this brings us to the fifth question. Now special attention over the not here. So we have to identify as to which of these is not a fundamental duty. Now please note that this is one of the questions which was directly from our question bank also. That apart, if you would have had access to our material, you would have had access to all this graphic material which could have easily helped you remember all the 11 fundamental duties. Now focus on the question again, because it is not talking about how many fundamental duties are there. We have to eliminate. So Article 51 of the Constitution talks about promotion of international peace and security. However, this duty is enjoined upon the state, and here we had to mark the option B, which was correct. Moving ahead, the sixth question is talking about the right to property. Now, as we all know, the right to property existed as a fundamental right earlier. However, with the 44th Amendment coming into place, it was taken away, and instead we now have Article 300A, which provides that no person shall be deprived of his property save by the authority of law. So therefore the correct option was B, that it is a constitutional right. This brings us to the seventh question, which is talking about parliamentary privileges. Now, as you all know, parliamentary privileges are enshrined within Article 105 of the Constitution of India. So now let us go option by option and get the answer. So 7A directly pertains to Article 105(1). 7B and C directly pertain to Article 105(2). Therefore, the correct option in this case was option D. So the 8th question was a bit difficult and direct. So let us first mark the answer. So the answer was M. Karunanidhi versus Union of India. It has laid down the test of repugnancy. Now repugnancy, as you know, pertains to the conflict of lawmaking between the center and the state. So this particular case law here concerned itself with the Tamil Nadu Public Men Criminal Misconduct Act 1973, which in fact was found to be supplementary to the Indian Penal Code and the provisions in question. So now the 9th question requires you to answer again directly as to under which schedule the transfer of tribal land to private parties for mining can be declared null and void. The obvious answer here being the 5th schedule. However, if I may add, this question is one where the examiner could have played a bit tricky in the sense that, please have a look here. So the 5th schedule concerns itself with the scheduled areas and tribes, and the 6th schedule also concerns itself with the tribal areas. However, the obvious difference being of ATM, that is the non-applicability of the 5th schedule to the states of Assam, Tripura, Meghalaya and Mizoram, and for which we have the 6th schedule here. Moving further ahead towards the last question from Constitution set, which is the 10th question, regarding the exercise of original jurisdiction of the Supreme Court of India. Now you could have easily gone through these options and take the correct answer, which is D, and it pertains directly to Article 131 of the Constitution of India. However, we would like you to have a look at this interesting depiction of the original jurisdiction. So it is concerning disputes between the center and the center with states against other states, and states versus states. So that is it from the Constitution set. I think 8 of these questions were rather easy, with 2 being slightly tricky. I'm sure you would have faced difficulty in these 2 questions only. So questions from CPC start pouring in from this 11th question. This one requiring you to answer as to who shall cause partition of an undivided estate assessed to the revenue of government. This was a direct question from section 54 CPC, which provides that it shall be made by the collector or any other gazetted subordinate of the collector. आपको यहाँ option A लगाना था. Now the 12th question. Before you begin reading this 12th question, a general note of caution. Often such long situational or factual questions will eat up your time if you read them more than once. Read such questions slowly and carefully. Here, one suit was filed on 6th of January 2020 and was never decided, but another filed on 18th of February 2020 for the same relief was decided. We had to examine the validity of the given statement that suit filed on 6th of January 2020 is valid and res judicata will apply on the suit filed in February as it was filed later. We had to simply, in terms of section 11, identify the former suit. The one filed later has been decided prior, so it is the former suit. Therefore, the given statement was false and we had to mark option B. Now my previous advice stays true even for question number 13. Read slowly and carefully. This is yet again a direct question from section 56 CPC, which prohibits arrest and detention of women in execution of decree of money. If you had taken our module 4, you could have easily marked this question as we had emphasized on this very provision. Now the 14th question pertained to abatement of suits, albeit imagined the situation where sole plaintiff had died after conclusion of hearing. B was the correct answer here. Interestingly, our 2 questions from the question bank were of direct relevance here and could have easily fetched marks for you. Notably, this was also a direct question from Order 22 Rule 6. You see, nothing remains after conclusion of hearing save and except the writing of judgment, and as such the suit would not abate. Judgment can still be pronounced. Now a suit filed in representative capacity cannot be withdrawn, compromised, etc. without notice to all interested person. So here the answer was B.
You see, solving our modules 2 and 9 could have ensured you killed this question. जी हाँ.
So we look at question number 16 and we see that it is again a direct question, each arising out of specific provisions. Now the correct answer in this case was that none of these statements are false. Now if you have followed us, you would know that this question concerns itself with basically three things: suits by minors, injunctions, and appointment of receivers. Now by following us, you would know very clearly Order 32 Rule 1, which talks about suits by minors being instituted through their next friends. You would also know that the bars under Section 41 Specific Relief Act would also apply under Order 39 of the CPC. Lastly, as per Order 40 Rule 1A, receivers can be appointed even before or after passing of a decree. Now the 17th question, I would say, is a happy coincidence because it is directly pertaining to sections 16 and 17 of the CPC, and yes, the suit would lie where the property is situated, and option A would be the correct option. Now that apart, I think the available material over here would be a quick recapitulation to your understanding of section 16 and section 17 of the CPC. Coming to the 18th question, I would request you to please allow me to applaud the examiner, for the question compels you to think that there is in fact a limitation to filing of an application under Order 9 Rule 7, be it 30 days, 60 days or 90 days, because the question proceeds in the manner so that one may think that there of course exists some limitation. However, there is no limitation. The correct option was option D. And you see, this provision pertains itself to the defendant appearing on the next date of hearing and assigning good cause. So there is actually no limitation under Order 9 Rule 7. So a court in session of an application for withdrawal of suit along with permission for grant of liberty to file a fresh suit is under the duty to reject or allow the application in toto. Now you see, the 19th question is talking about one of the safeguards against res judicata. You can take permission and file afresh under Order 23 Rule 3 in two circumstances. One being there being some formal defect as a reason of which the suit fails, or if there is sufficient reason to grant permission to the plaintiff to file afresh. Now this 20th question looks possessed with some high level of difficulty. See, you had to know Order 21 Rule 37. Now here option A is show cause, B is warrant, C is attachment before warrant. Now D was the correct one. Now even if you did not know Order 21 Rule 37, you would know that one has to be afforded proper opportunity in law. At the same time, there are available coercive processes for those fleeting justice. Now option A was the opportunity and option B was the available coercive process under law as a proviso. Therefore, option D was the correct one. Now I'm sure you can converge better at answers to questions you're finding some difficulty with. So the question number 21 is concerned with ex parte injunctions. Now Order 39 Rule 3A के according, अगर एक कोर्ट ex parte injunction देती है किसी को, तो that court shall endeavor कि इस इंजंक्शन एप्लीकेशन को 30 डेज में फाइनली डिस्पोज कर दिया जाए. सो यहाँ पर आपको ऑप्शन ए लगाना था, जो कि एक डायरेक्ट आंसर था स्ट्रेट फ्रॉम Order 39 Rule 3A. Now the 22nd question was another very specific one and a rather tough nut to crack. You see, it is straight away asking about Order 21 Rule 90. Still, लेट अस सी आप कैसे कन्वर्ज कर सकते थे ऑप्शन बी पर, जो कि आपको लगाना था. यू सी, अगेन फोकस ऑन द नॉट ओवर हियर. सो हमें यहाँ पर एलिमिनेट करना है. आप देख सकते हो कि ऑप्शन ए, सी एंड डी आर डिस्क्रिप्टिव. यू सी, ये सारी चीज़ें होनी चाहिए थी. नाउ ऑप्शन बी अगर आप देखेंगे तो इट इज़ रेस्ट्रिक्टिव. क्यों? बिकॉज ऑफ द अलोन ओवर हियर. सो बाय इम्प्लीकेशन बी कैन नॉट बी दी consideration, because अगर ऐसा होता तो it would have been the sole available option over here, right? In any case, also look at the beautiful depiction we have for this answer over here and go through it. Question 23 एक और direct question है. In this case आपको option C लगाना था. जी हाँ, representative capacity में suits are foiled as per order 1 rule 8. Now a simple example could be the case of Tamil Nadu Housing Board versus Ganpati. In this case, you see residential building के allottees ने case किया था in a manner of a representative suit which was found to be maintainable. Now question 24 is another opportunity to analyze this paper. You see this is also concerned with abatement. So यहाँ पर आपको option C लगाना था that no fresh suit shall be brought. Now एक analysis हम लोग यहाँ पर कर सकते हैं that largely questions have been revolving around abatement and dismissal of suits, withdrawal of suits and the principles of res judicata. So it has been coming time and again in this short span only. So please keep it in mind for the next exam, for the next paper that you have to give. If there is something I am super sure about, बिल्कुल मुझे मालूम है कि आपने क्वेश्चन नंबर 25 तो एकदम सही लगाया होगा because it was from section 9 CPC which says that court shall have jurisdiction to try all suits of a civil nature save and except cognizance of which is expressly or impliedly bar. I am sure आपको expressly or impliedly bar याद होगा and you would have marked the correct option.